Hi AI class, this is Professor Opterbeck. In this video we're going to talk about some of the additional obligations on providers of high-risk AI systems under Article 16 of the EU AI Act. And in particular, we're going to look at the requirement to do a conformity assessment. We're going to look at the requirement to do a declaration of conformity. We're going to look at the requirement to apply certain markings, and we are going to look at registration obligations. Now in Article 43 are the requirements for the conformity assessment. And this section is written in a way that's pretty confusing, but before we drill into it, let's just step back for a second and compare this to privacy law, including the GDPR. So in privacy law, we have the concept of a privacy impact assessment, or PIA. And the PIA in privacy is a well-known tool that has been used for a number of years now, and really is the analog of the conformity assessment under the AI Act. So the idea of a privacy impact assessment can also in the GDPR be called a DPIA, a data privacy impact assessment, is that you're going to do a review of the product or service that you're going to be putting onto the market and identify all the kinds of data it's collecting, the way that data is flowing, how that data is being secured, what sorts of data risks, privacy risks the application or service poses, and what steps are being taken to mitigate those risks and to comply with the privacy law. There are many cases in which you might voluntarily want to conduct a PIA or a DPIA. In fact, really best practices is whenever you're putting out a new product or service that is interacting with PII, with personally identifiable information, it's a good idea to do a privacy impact assessment. Under GDPR, there are certain circumstances under which you have a requirement to conduct a privacy impact assessment before you put the product out onto the market. So now take that general concept and bring it over here into the EU AI Act. And what you'll see is that for any high-risk AI system, as defined in the regulation, you are always going to have to do a conformity assessment. So whenever you're putting a high-risk AI system out onto the market, you've got to do a conformity assessment. Now, the kind of assessment you might have to do is going to differ depending on what kind of product it is, what kind of AI system it is. So there is what's called an Annex 5 assessment, and there is what's called an Annex 7 assessment. And you can take a look at those annexes yourself. We won't scroll down and look at them in detail right now, but you'll see that all of them are talking about similar kinds of things to a PIA. So you're collecting information on what your system is doing, on how that system works, right? All of the kinds of technical documentation, instructions for use, what kind of data is collected, how it's been trained, all that sort of documentation that you are supposed to be creating under the AI Act. You're bringing that all together into a document, and then you are making an assessment of the risks to basic interests that your system poses, and then to the steps that you have taken to mitigate those risks as required under the Act. So for example, where is the human oversight? How does the human oversight function? How is it that a human being has the ability to turn the system off? Where are the transparency requirements? How is notice being delivered, right? You're documenting all of those things, and you're making an assessment. And obviously, if your assessment is that what we're doing doesn't conform to the Act, well, then you've got to change what you're doing, right? So at the end of the day, you really have to be making an assessment that, yes, we are compliant with the Act, and here are the steps we have taken, right, and documenting those steps. So they're similar in that way. One of the biggest differences is going to be between the Annex 7 and Annex 5, whether you have to involve a notified body. All right, I'm going to say notified body. a little bit sloppy in my writing here, right? But whether you have to involve a notified body. And a notified body under the EU AI Act is a body that is set up in the a national authority that is set up within each of the member states to receive and review these conformity assessments. So under an Annex 7 conformity process, a notified body needs to be involved, and under the other Annex 6 process, then it's simply an internal audit that you're documenting, but you don't have to involve the notified body in the process, right? So as you might gather, the high-risk AI systems that are understood in the Act to be more sensitive than others might require the involvement of a notified body, while high-risk systems that are a little less sensitive than others, yet still high risk, don't necessarily have to involve in the initial assessment itself a notified body. So what is that distinction? Well, that distinction is, you can see here listed in point 1 of Annex 3. Point 1 of Annex 3 is biometrics. So if you have an AI system that involves biometrics, then you may have a requirement to use the Annex 7 procedures and to engage a notified body. Now, I said you may have a requirement because notice here these references to harmonized standards in Article 40 and common specifications in Article 41. So we'll just flip up here a little bit. Again, we're not going to read all of these regulations, but notice here there's a reference to an official publication in the EU for harmonized standards, and notice that this refers to high-risk systems and general-purpose models. And then notice here that there's a reference to the European Commission potentially adopting common specifications. So the idea here is that there's going to be a governmental source that is a repository for specifications and standardization, and the government may publish some of those, the government may receive some of those, and then have them published in an official place, right? And so these standards are pre-approved. You can kind of think of this a little bit like NIST standards in the U.S. We've looked at NIST standards in cybersecurity and privacy and AI in our different cyber and privacy courses here in the law school. And so NIST is publishing standards that are kind of recommendations, but it publishes a whole bunch of standards in a whole bunch of different areas, and some of those standards then are adopted into federal regulatory frameworks that say, you know, here's sort of a baseline for, you know, the safety of a certain kind of product or the accuracy like of a measurement tool or something like that. So it's a similar idea, government publishing in an official journal or the government itself promulgating certain standards or specifications. And if you think about this, especially for kind of the repeatable aspects or maybe reusable aspects of a technology, including AI technologies. All right, so if you are doing biometrics and you are basing it on some of those published standards or promulgated standards by the government, then you actually have a choice between whether you want to do the self-assessment or whether you want to involve the notified body. You know, why would you want to make one choice or the other? It might depend on your risk tolerance and your tolerance for, you know, having the notified body kind of be involved in your process. So the trade-off for having them involved in your process is that at least you have a little more confidence when it's done that the process at the end of the day is going to be acceptable. But of course, the trade-off for that is they're involved in your process. Now, all of these things, and of course, if you are not biometrics, and so you're one of the other categories, you're of high risk, then you're going to be looking at this internal kind of self-assessment type process. We should note also that, as we have seen, there are other kinds of potential high-risk AI systems that are parts of other kinds or safety components of other kinds of regulated products. So there we've again got reference to some of these harmonized standards and to the fact that these other products have their own regulatory approval frameworks. So let's say that your AI system is part of a machine that is moving cargo around in a warehouse, right? So a robot machine that's moving cargo around in a warehouse. That machine might have its own kind of regulatory requirements just as machine, like as a lift machine, load capacity and things like that. So you've got to look at both of those things if you're doing that. So again, if you go through the Annex 7 process, you have a little bit of comfort that the notified body is already involved. If you go through the other process, you don't necessarily have that. But in either case, what you're doing is you're documenting for the later purpose of if there is a question that, in fact, your product hasn't complied or whether your product has, in fact, deviated from the process that you have gone through. So now looking back at Article 16, we have talked about the conformity assessment procedures. Let's talk now about the declaration of conformity in Article 47. So Article 47 tells us about the declaration of conformity. The declaration of conformity is a file, a machine-readable document, and it is required for each high-risk AI system and is to be made available to the competent national authorities, which is going to include the national authority that is going to be established under the AI Act to regulate AI for 10 years. And it needs to confirm that the system meets the requirements of the Act and include various information set forth in Annex 5. So let's take a look at Annex 5. And so here is Annex 5, which discusses the information required in the declaration of conformity. So it requires some way of identifying the system, who the provider is, and confirm that, in fact, the system is in conformity with the regulations. And if the conformity assessment has been done according to any harmonized standards or common specifications, as we mentioned earlier, that needs to be referenced. If a notified body was involved in the conformity assessment, that needs to be noted there as well, and then it needs to be signed by a responsible person. Now notice that none of this is involving the prior approval of the EU to put the product onto the market. So even for a high-risk AI system, we're not talking about something like a drug approval, where you need first a governmental evaluation of safety and efficacy through clinical trials before you can put the drug onto the market. So it's really not that kind of process. It's a process that involves some kind of self-assessment, and in certain cases, self-assessment also with some governmental assistance or involvement in that assessment. And then a self-evaluation that results in this notification and declaration that is, signed by responsible people who are going to be held responsible in the event that the product, here the AI system, does not in fact conform in the way that it's supposed to conform. So it's not a pre-approval, but it is a requirement to do a self-assessment and then to put that on record so that if there's later a problem, there's a demonstration of what's supposed to be the case with the product, and then an indication of what went wrong, and then someone to hold responsible. Now back to Article 16, we see that when the conformity assessment has been done and the declaration of conformity has been drawn up, then the CE marking can and must be affixed to the system or to its documentation. Well, what is a CE marking? A CE marking is a marking that is used throughout the EU on a wide array of different kinds of products where there is a regulatory obligation of going through a specification and conformity process as there is with AI. So you should see from this whole process that the EU is treating AI like it treats other kinds of regulated products that present some kind of risk to the public, but that also have some kind of utility for the public. And we can go back to the classic example of, say, a lawnmower or an automobile, right? Things that we use often that could be dangerous, that need to be manufactured with certain safety things in mind, but that generally aren't pre-approved in the way that drugs are pre-approved. It's not all that different in the U.S. We might not get have an official government filing for something like a lawnmower, but there will be requirements in the Consumer Product Safety Commission and so on for how the thing is manufactured, and there may be liability on the back end if the thing does not conform to some of those requirements. All right, and then finally we see here in Article 16 that the provider must comply with the registration obligations in Article 49. So let's take a quick look at Article 49. And Article 49 tells us that there is going to be an EU database for these kinds of high-risk AI systems, and that before placing the product onto the market or putting it into service, the provider must register the product in that database. So all of the information that we're talking about is then going to be accessible to the regulatory authorities and is going to be accessible to the public.